Law and Crime.
The jury will not be sequestered.
I'm Brian Buckmire, along with Terry Austin.
In the Weinstein case, fellow silence breakers and any
Selection is moving along
Well,
here.
I'll read the verdict, says Jesse Weber. Thanks for joining
We
us.
don't tend to see it as raw as this. Good evening and welcome.
Well, as you know, Brian was charged with certain crimes relating to a credit card and some fraud issues. You generally can't prosecute a dead person, but there are some open chapters that need to be closed, and those discussions will remain to be had in the coming days and weeks.
But that was Stephen Bertolino, the attorney for the Brian Laundrie family. My name is Bob Bianchi. This is For the Record on the Law and Crime Network. I'll be taking it to 3 o'clock. We got a lot on the plate today. The trial death of Ahmaud Arbery, as well as a hearing on Kyle Rittenhouse. Markeith Loyd jury selection is wrapping up finally in that case. And new updates on the cold gun case with Alec Baldwin, the incident in which 2 people were tragically shot, 1 killed on the set of Rust. But now, new updates on the person of interest, Brian Laundrie, the fiance of Gabby Petito. Last week, his body remains were found and identified. However, cause and manner of death has not been brought forward because the body is in a state of disrepair and because of the elements. It is now in the hands of anthropologists with regard to whether or not they can try to determine the cause and manner of death. I have Darren Gelber with me. He is a former prosecutor and an attorney, trial attorney. Darren, let's get to this. Bertolino says you can't prosecute a dead person, but some doors that are open need to be closed. In your mind, Darren, what exactly does that mean?
Well, I think that he's trying to subtly say that questions surrounding how Brian Laundrie died, maybe the contents of that notebook or whatever else was found near the body of Mr. Laundrie may help shed some light on how Gabby Petito died. Whether there are any admissions in there by Brian Laundrie that he had a role in that. I think he's trying to say that when there's a full explanation of the circumstances of Brian Laundrie's death, that the public and the family of Gabby Petito may have some closure on that situation and information about how she died.
Yeah, interesting. Stephen Bertolino has a lot to say, and there's obviously a lot of public criticism about him. We're going to talk about that a little bit longer, but let's listen to a little bit of our very own Anjanette Levy in an interview she did with Mr. Bertolino.
Well, working backwards, I can tell you at this moment in time, we have nothing to say to the Petito family. Right now, Chris and Roberta Laundrie are just focusing on retrieving Brian's remains from the medical examiner's office, grieving their sons and dealing with that. And in the future, we'll see what happens with respect to not speaking to the Petito family in the beginning. That was on me. That was something that I told them they shouldn't be doing. And we're just going to leave it at that. There was never an indication that charges were pending or imminent. There were just conversations with respect to, what do the parents know? And certainly, would we be willing to talk to them with respect to that? And that was just some back and forth that was going on. But there were never any imminent charges pending, to my knowledge.
Darren, again, as I indicated, this attorney has been getting a lot of heat for the advice that he gave to the Laundrie family. And I'm curious about your opinions as to whether or not the advice he gave would be the standard, typical advice that any criminal defense attorney would give, especially when the law enforcement authorities and family attorney for Gabby Petito were in the news saying he's a person of interest, and we believe that the family should be cooperating with law enforcement. Would you have given that advice? Is that common advice to say, listen, you need to be quiet because anything you say could be used against you? And the Fifth Amendment right to remain silent, we know, Darren, protects the innocent as well as the guilty. Thoughts?
Well, Bob, I can tell you that in circumstances where I've represented people under investigation for causing harm or the death of another person, I have routinely, as a matter of course, told them that they should not speak to anyone, including the family of the person who may have been injured or killed. I think that's probably Defense Lawyer 101. At the same time, you don't want to appear heartless. You don't want to appear disinterested. You certainly don't want to appear arrogant. And quite often, I have made requests of law enforcement or a prosecutor. Listen, I've advised my clients they shouldn't be saying anything to the family of the other person, but would you please convey that they are deeply concerned? You know, try to sort of back channel some communication that the reason there's no public comment or the reason there's no personal contact is because of the attorney, not because the family's heartless or not interested. So I do think as far as that advice goes, it was proper and it's something I would expect.
Yeah, it's been surprising to me, Darren, to be listening to so many attorneys. I don't know if they're just TV attorneys or they really practice in real life that have such vitriolic feelings. And we understand that everybody wants to know what happened to Gabby Petito, but he is representing the Laundries, not Gabby Petito. And so his interests are different there. But I wonder now that the body has been found of their son, if they do have information. I mean, the Petito family, I think the investigation should not end here. As a prosecutor conducting a homicide investigation, I would be dotting I's, crossing T's to rule out third parties or, you know, any kind of other kind of nefarious activity that's at play. But would you expect now that maybe the Laundrie family will be more willing to come forward knowing that their son is no longer alive?
I think so. And at the same time, there's also lingering concern about whether they could be charged with hindering or obstructing, whether they provided their son with any assistance or did anything to help him hide himself from law enforcement. Of course, they would face possible prosecution for that. So that may be the subject of discussions. I don't know. I'm purely speculating. Maybe there's discussions underway about whether members of the Laundrie family would agree to provide information that they know under some agreement that their statements can't be used against them in any prosecution for hindering. Even though Brian is dead, you still have to worry about the rest of the family.
Absolutely. I mean, they could make a mistake, an innocent mistake, and then all of a sudden by another prosecutor could be perceived as being a lie, then it's hindering. Now you're being charged. They're trying to extract additional information from you. Unfortunately, that happens, and that's why defense lawyers are very protective. Let's listen to a little bit more of this interview with Stephen Bertolino with respect to the Laundrie family as their attorney and what it was that he was doing in advising them with respect to this case.
As I've said numerous times, I've represented the Laundries for well over 20 years, or I should say Chris and Roberta Laundrie in different matters. I have business dealings with Chris Laundrie through my office, and I speak to him frequently. I'm not at liberty to say the exact date that we spoke about, this particular instance at this point or at any point in the future. That information would be privileged.
Darren, a lot of people have been asking the question as to how far the attorney-client privilege goes. And I find this also as a lawyer to be a really interesting question. Is there a bright line where you have it and you don't, assuming you're not participating in a fraud as an attorney? There's a fraud crime exception. Does the attorney-client privilege end at any point in time in your mind?
The law may be a little different in different states, but I can tell you that the attorney-client privilege is considered probably the most sacrosanct and the most protected of all privileges. And in many states, the privilege continues after the client has died. And certainly the privilege protects those, including members of the Laundrie family who may, and again, this is speculation, may have helped their son and maybe wittingly or unwittingly committed obstruction type of offenses. Certainly that's protected. And so the attorney-client privilege is something that the public doesn't really understand, and they may cry out, how can this be? How can they be allowed not to cooperate? But that is a bedrock, really, of our system of justice, that you have the right to communicate freely with your attorney without fear that what you say is going to be disclosed to third parties.
Darren, one last question I want to get to is how this case was handled in the beginning, your thoughts on it. By getting out there, and I gave lots of press conferences in my career, and calling somebody a person of interest, you already are setting up the pucker up factor, as we used to call it. Again, that defense lawyer is going to say, remain silent under those circumstances. But also their failure to track him has come into play. Was there something they could have done more in order to ensure that when he left his parents' home back in September, that they had at least some idea of his whereabouts. What are your thoughts about it?
I mean, I don't really know. You know, the police department is being criticized for, this feeling that they let Brian Laundrie escape out the back door, so to speak. But at the time that happened, I presume, although again, I don't know, that the house was being under some sort of watch by the police, but it's not like they could surround the house, with 50 police officers all day and all night to watch who's coming and who's going. At that point in time, while he certainly was a person of interest, they did not have sufficient evidence to charge him. Let's not forget that the credit card related charges did not come till later. So I'm sure there's going to be a full accounting of all the police activities at some point where we'll have a better idea of what they did and why they did it. And at that point, we can have a more fact-based discussion. But right now, I can't really find fault that I can put my finger on for the fact that Brian Laundrie somehow got out and went on this hike and eventually turned dead.
Yeah, Darren, he was a person of interest, i.e. he was a suspect. I had tails and surveillance on all sorts of individuals like that. Today we have drones and all sorts of activity. Maybe it was something, clearly he could potentially be a flight risk, especially if they knew his background. But you are right, we'll wait for the facts to see what they are with regard to why they did and didn't do certain things. Okay, guys, got to get a lot on the plate. Like I said, Ahmaud Arbery is next, but don't go anywhere because we have our very own Brian Buckmire, who is on the street, is going to give us a background of what's happening out there. So stay with us. We'll be right back. Ahmaud Arbery case, jury selection going very, very slowly. Over 1,000 prospective jurors have been impaneled for that particular case. As of last week, they had 23 jurors. They're trying to get to 64 in order to come up with a jury of 12 jurors and 4 alternates. The counts, obviously, including murder and various other offenses that all 3 of these defendants are charged with. We have our very own Brian Buckmire that is out there in the Glenn County Courthouse. Brian, I can only imagine the sentiments that are going on there. A lot of these jurors apparently afraid to actually sit on the jury. Give us an idea of what it looks like out there, Brian.
Yeah, so Bob, outside here, just as you can see in the background, this is the Glenn County Courthouse behind me. And off to the side, I'm not sure if you can hear some of the spiritual songs that are being sung, but from time to time, there's about 10 to 12 supporters of the Arbery family here talking about justice and also about getting out and voting. From time to time, they'll break out in song and singing in support, not only of the Arbery family, but for all families who have been victims of killings in such a fashion. Inside the court, a little bit of action is actually happening. We're going through jury selection. Ahmaud Arbery's father is actually in the court, and one of the jurors was question number 380, a 60-year-old African-American man who spoke about his background, but also that he saw the video, he had an opinion, but he could put that opinion to the side because he believes the video didn't show everything. A bit of entertainment or a bit of drama in the courtroom that we did see is that when he walked out, supposedly the defense said that they saw Arbery's father give the prospective juror a head nod. This came up. The prosecution said they didn't see it, and the judge said it will be noted for the record, but they kept it moving, business as usual.
I'm interested. So the judge is not going to do a voir dire of that juror, Brian, to bring them in to see, to make that determination. It's not the only incident that the defense has brought up in that courtroom with respect to the family potentially influencing, for example, wearing certain pins and various things in support of Ahmaud Arbery. Tell us a little bit about that.
Well, last week, Bob, I believe the head nod came up again, so this may be a reoccurring thing that the defense is looking at. I'm not sure if it's the typical head nod that one individual seeing another individual walking by will say hello to. Of course, Bob, you know, as lawyers, we are in a strict rule not to have any interaction with potential jurors. You can't even open doors for them. You can't let them go through doors first. You don't want to show any kind of impropriety. This may be a situation where Mr. Arbery's father is simply just being polite, or it could be as a defense is suggesting. But this is, from our understanding, at least the second time that it's occurred. I believe last week, Thursday, it occurred again, and the defense did bring that up.
Brian, you're an excellent trial lawyer. That's why I always love having you on as a guest. Let me ask you your thoughts. And, we always try to game this even like what the verdict is going to be. We all know it's a fool's errand, but I'm going to ask you anyway. Are we going to get a jury this week, Brian?
I don't think we're going to get a jury this week. Just the nature of how we're moving in terms of not just questioning prospective jurors, but also bringing them in at a time. You gave that magic number of 64, and the way we're kind of getting to that number is by breaking down how many jurors will be on the panel. That's 12. How many alternates we need. That's 4. And then we're also looking at the amount of strikes that each side has. Don't forget, all 3 defendants have 8 each. That's 24. Then, of course, the prosecution has their own strikes. But don't forget, even in that 64 number, there can be people that are removed for cause. That typically happens at the beginning of jury selection. You say, hey, I can't be impartial. I can't do this. But of course, Bob, as you know, you start questioning, you start asking people questions, and it's not that they're particularly hiding anything, but perhaps they start digging and evaluating into their own past, and they start to realize themselves, hey, I might not be a good juror. The best example I give people is, as much as I am a defense attorney and pretty pro-defense, my grandfather was killed by a drunk driver. And so I've reflected upon that in my own life and said, you know what? I could probably do a homicide case or a stabbing case, but a drunk driving by death case, that may be too close to home. And that may be a conversation I use as an example that a lawyer may have to pull out of me if I didn't think about that as being the lawyer that I am now, that they might be struck for cause down the road. And so we may see more potential jurors coming up than just the 64, but we're hoping that that number is the magic number and we can seat a jury sooner rather than later.
All right, awesome. Our very own Brian Buckmire out there covering it. Gavel to gavels we do here at the Law and Crime Network. Thanks so much, Brian. Great seeing you, buddy.
Thanks, Bob. Always a pleasure.
Okay, great. And you know, listen, the questioning of these jurors is an essential part of the voir dire process. It doesn't happen in every state, doesn't happen in my state, where they literally get to pull out that data and information that Brian was just talking about. Let's listen to a little bit of some of the defense questioning of jurors in this particular case.
If you have thoughts about wanting to limit gun rights and have expressed those through political choices, any type of limitation of guns whatsoever. Number 39, number 50, 72. Very good, thank you. Please raise your hand if you oppose, disagree with, don't like it when people or laws that allow people to carry guns openly or concealed and into public places like a grocery store or a mall or wherever they want to carry it to. If any of you oppose those laws that allow people to do that, you don't like that, please raise your hand. Number 50. Okay. So we've had a lot of conversation about this case. There's been a lot of gathering about this case, whether it be here or elsewhere in the state of Georgia. Have any of you participated in any of the demonstrations or the marches or the gatherings in and around the social justice movement that's happening in our country? That could be before the shooting in this case or after the shooting in this case. You would have gone somewhere to participate in that conversation or movement. Number 42. Okay. Now getting a little bit more specific, not necessarily participating in marches or going to places where there are conversations, but supporting in any way the Black Lives Matter movement. Please raise your hand if you feel you have ever been denied an opportunity because of your ethnicity, your gender, or your race. You feel that you've been denied this because of your ethnicity or your race or your gender. 69. Very good. Specifically, you were asked a question about being falsely accused, but I would like to expand that a little bit about, or narrow it a little bit, being falsely accused of doing something wrong or being looked at suspiciously because of your race or ethnicity. where you feel like you've been judged or people have been suspicious about you and that's been a personal experience to you based on your ethnicity or your race? No one. Excellent. Please raise your hand if you agree with this statement. The old Georgia state flag, the one that was essentially in operation from 1956 to 2002, that flag is a racist symbol.
All right, defense questions of jurors. Julie Rendelman is now joining us as well. Welcome back to the show, Julie. Always great to have you, and hope you're doing well.
Thank you, Bob. Good to see you.
Good to see you. Okay, guys, I got some updates about some of this jury selection stuff. So today we have 19 jurors that showed up this morning. One juror was dismissed because she doesn't speak English or understand English well enough. She had her daughter with her. 2 jurors knew Ahmaud Arbery personally, members of his family. 1 juror knows Greg and Travis McMichael through work. The 4 have plans that they can't change and say they can't serve. And 2 jurors raised their paddles when asked if they had a relative or close friend who may be charged with, who have been charged with a murder. So, guys, let me ask you, Julie, let me start with you. How much longer? I mean, this has been a really arduous jury selection. A number of jurors have expressed concern about sitting on the trial itself. We all know that jurors can find the excuses that they want in order to not serve on the jury. Do you see this being a much more tedious and lengthy process as we move forward?
Yeah, I mean, I don't think it's going to really change. I mean, we have, a case that's, going to have a lot of repercussions, and jurors are, some are just not going to want to sit on it, period. And so some are just going to find excuses, whether or not they're valid excuses or not, whether they're truthful or not. We don't necessarily know because we don't have a lie detector test on each of the jurors as they come through. But a homicide, by the way, Bob, in general is hard to sit jurors on, let alone a case of this magnitude. So I think it's going to be very difficult. I think you'll get one. I don't think you're getting one this week, and you may not even get one next week. It's going to take a long time. It's going to be quite tedious.
Okay, there's 2 motions that are pending by the defense that have to be heard prior to the trial. Darren, I'll toss the first one to you. And that's a defense motion that they want to introduce that there was THC in Ahmaud Arbery's blood. What do you think of that motion and the success of the defense, if any, in winning that argument?
Not coming in, Bob. Judge Gelber rules it's not coming in because it was not known to the McMichaels at the time. And so could have played absolutely no role in their decision-making. It could not have affected what they chose to do or not to do, or how they viewed Mr. Arbery prior to this shooting incident taking place. Under those circumstances, the only possible reason to try to get that evidence in is to really dirty up the character of Mr. Arbery. And that's certainly not an issue for consideration by the jury, not coming in.
Okay, interesting, Julie, because the second motion, and I wonder if the same logic would apply, is that the defense is trying to ensure that the license plate, the vanity license plate on McMichael's truck, which has a Confederate flag on it, is not shown to the jury. Does that have any relevance, and should that be excluded? Will the defense win that motion?
So no, I don't think it should be excluded. I'll be honest. There's 2 issues. One is, it is possible that Ahmaud Arbery, when he was fleeing, saw that, and to many who see that as an indication of racism. That could scare anybody. I'd be running from a truck that had that as well, to be frank. And so I think it's arguably relevant. 2, that is the car they chose to drive that day. And so I'm not sure the basis. I don't think the prejudice outweighs the probative. By the way, some don't view that symbol the way I do. Some view it very differently. So I'm not sure that it'd be overwhelmingly prejudicial. Sorry for my words not coming out that clearly today.
It's Monday, Julie. No worries at all. Listen, we have a lot more on the plate here. Markeith Loyd, jury selection going on, another case of great national importance. So we're going to cover gavel to gavel here at the Law and Crime Network. And when we come back, he's got a penchant to speak out his mind, if you will, quote unquote, in the courtroom. and we've got some of that happening. We're going to talk about it on the other end of the break. Please stay with us.
I still may tell all of you that you can't talk about Dixon in opening, all right? It's been an extremely long day, and I never make decisions at the end of days like this, but both sides should be prepared to be told on Monday, you will not mention Sade Dixon in opening other than to say there was a warrant for the arrest in her homicide, and that's it. And then I'll see what happens during the trial, okay? Just be prepared for that. Thank you, folks. It's court's in recess.
Sade Dixon, it was the ex-girlfriend who was pregnant that Markeith Loyd, because we covered this gavel to gavel, was convicted but spared the death penalty. The argument here is that he killed Lieutenant Deborah Clayton while he was on the run for 27 days. A Walmart customer alerted law enforcement authorities. Lieutenant Deborah Clayton showed up, had apprehended him, called for assistance, and it is alleged that Markeith Loyd shot and killed her. This, again, is a death penalty case. And the other issue in the case is whether or not a claim of insanity will be successful in this particular matter. So let me go to you, Julie, on this. How big a role should Sade Dixon's conviction play in the trial? Because what we're hearing the judge say is, I have not made a decision yet as to what extent I'm going to allow. You know, Julie, we talk about this all the time. It's that 404 evidence or other act evidence. It may be relevant to motive, but will be overly prejudicial to bring out what the crime was. What do you think is going on here and how the judge will rule?
So we kind of think back to Durst, whether the judge wants to have a case where it's basically a trial within trial, and she doesn't want a situation, I assume she's not going to want a situation where they're having to prove the original murder case to prove this one. However, I think it is relevant. I think the question is how much should be let in? I think the jury must know that there was that he's accused of a killing, because that explains whether or not he acted intentionally when he killed the officer. If he's fleeing from a petty larceny, it might be a little different than if he's fleeing and knowing he's fleeing from someone who believes he committed a murder. And so I think the judge has to let them get into it. I just don't know how far in the weeds she's going to let them go.
Yeah, Darren, had a case just like this as a prosecutor where we really debated whether we should get into what the warrant was for, because the warrant was, it's the quality of the warrant. If there's a warrant just for receiving stolen property or for taking a car, it's one thing, but the motive is what's important here, and being possibly charged with the murder of his ex-girlfriend gives the jury more of a reason to understand why he would have resorted to murder on that warrant. Do you agree with the proposition that Julie brought out?
I agree 1,000%, and I think the judge is drawing the line just where the line should be drawn, and that is that there was an active warrant for his arrest, and it was for a crime as serious as murder. And that's it. I mean, the prosecutor should not be allowed to get into details of how the murder was supposedly committed. Certainly should not be allowed to elicit information that he was convicted of the murder. That's got nothing to do with it. The jury's entitled to know that this was not a warrant for an unpaid parking ticket. So the issue of the murder, I think, is relevant. But beyond that, any more detail about the murder and how it supposedly happened and whether or not the defendant is guilty of that murder should not come into play at this trial.
Yeah, well, what a difference between that and the Durst case, where they were allowed to show photos and talk about what the verdicts were. They were trials within trials with regard to Morris Black. It is such a difference and probably more akin to what it seems like we're used to in a courtroom. Well, on Friday, the defendant, again, he's been very vocal, has decided, well, maybe it's better that I represent myself. Let's listen to a little bit of that exchange.
Mr. Loyd, do you, well, first of all, I'm not doing a Nelson hearing because the trial has begun. There's a jury's veneer has been sworn. So, Mr. Loyd, do you want to represent yourself? Or you want to keep your lawyers?
Yes, I want to represent myself.
So you want to fire your two lawyers?
No, I want to be first chair, second chair, how I had it for last time. And since Terry know everything, I got to keep Terry.
Okay. And what is the reason that you want to represent yourself?
Because things are being done and it's not being done right, and my life is on the line. They're just like, even with the situation, and I told them I only want the fact for my mind, it was my mind state that the police was trying to kill me. They reported I came over here to my child's mother house, banged on the door, and gunned these people down. That never happened. Everyone's seen my trial, so y'all know a fact.
Mr. Loyd, focus on what we're talking about. So you don't like the rulings that the court is making, or you don't like?
I don't like the ruling the court is making and the arguments and the stuff that's being put forth on this side, because it's not. I'm upset right now. I can't even talk good right now, and I can't talk to them. I'm upset.
Okay. Anything else about representing yourself? Mr. Lenneman, would you or Mr. Marrero care to put anything on the record as to that? All right. Mr. Loyd, we've been down this road before. You asked to represent yourself. I granted your motion. You struggled. You then asked me to appoint Mr. Marrero as co-counsel. As I've repeatedly explained to you, you are not an attorney. You are not lead counsel. I did that. I appointed Mr. Marrero as co-counsel. You then told me that you could not represent yourself because of the restrictions that you have, because you are an inmate and you were unable to effectively represent yourself, and therefore asked me to reappoint Mr. Lenneman as your attorneys, and I did that. The case law is clear that while defendants have the right to represent themselves, they do not have the right to go back and forth. You can't decide that you want to represent yourself, then you don't want to represent yourself, then you want to have an attorney, then you don't want to have an attorney, then you want to have co-counsel. The court has observed and acknowledges the following, which is that, quite frankly, sir, you are an inmate. You were unable to effectively represent yourself the first time I granted it, and nothing has changed at all in your situation. The motion to proceed pro se is denied. You continue to have lawyers, and you continue to be allowed, as you have been throughout these proceedings, to actively participate in your defense. The court has given you the opportunity to speak when you've wanted to. I have observed, as has everyone in the courtroom, that your attorneys take direction from you. When you want something done, they stop and they do it. So the motion to represent yourself is denied. We are here on Monday morning, courtroom 23, for jury selection.
Darren, the defense here is insanity, that he believed that the cops were going to kill him. Now he wants to represent himself. Even if the judge were to allow it, how complex a situation would it be for a defendant representing himself trying to bring out an insanity defense? And does that sound rational to you, that he thought the cops were going to kill him, or irrational?
Well, let's put that aside for the moment, your last question. You know, the first question, allowing him to represent himself under these circumstances would be a recipe for disaster, in my viewpoint. And, you know, the judge bent over backwards to try to accommodate an earlier request. He then reversed himself and asked for counsel. She reinstated his counsel. And there are many, many defendants who suffer from mental illness of one sort or another. I don't know about this gentleman, but it sort of reminds me of, do you remember the Colin Ferguson case in Long Island, Bob? A gentleman with severe mental problems opened fire on a crowded commuter train and then represented himself at his trial. And it was awful. It was awful to watch. And you could see how uncomfortable it made everyone. And you can see what a disservice Mr. Ferguson did for himself in attempting to represent himself. This gentleman on trial here, he needs experienced counsel. He needs counsel who know the law. A defendant is not entitled to dictate every part of his defense, which is a shock to many people. Criminal defendants are entitled to make certain pivotal decisions, whether to plead guilty or go to trial, whether to testify on their own behalf or remain silent. But once they're represented by counsel, the responsibility falls to counsel to make many important strategic decisions. And you don't have to follow every single thing that your client wants. It's your obligation to protect your client's interests. So I think the judge made a wise decision here.
Julie, in your experience, why is it that a defendant, is there a theme here, why they would want to represent themselves?
Well, I mean, one argument would be that they're mentally ill, and so that they feel that no one can best represent them as they can themselves. I'll be honest, you know, it's interesting, you know, we've been the most nervous on cases where defendants represent themselves. Why? Because sometimes the jury feels so bad for the defendant that they give him some credit. I'm not sure that they would do it here, although I would say that if he is so mentally ill, it would show much more clearly if he was representing himself than it would be if he's represented by others. Look, I think the judge, made the right call. And by the way, again, keep in mind, this is the second time he requested it. He realized the first time he couldn't do it. It was too burdensome. He didn't have access to things he needed. And I think she really made a good record, by the way, as well, by articulating that he's able to communicate with his attorneys. It's clear that his attorneys listen to his advice and use his advice when it's appropriate. So I think she's making the correct record, hearing him out so that he doesn't get too excited because he seems to get angry pretty easily, and she seems to handle him quite well.
Darren, originally when he spoke to police, he indicated that the officer pulled her gun out and that she should have waited, according to Markeith's world, for the backups to show up. And so it was more of a self-defense kind of claim. How does that work now that he's arguing insanity? That seems kind of be in opposition of insanity, making it even more of a sophisticated defense, no?
Well, it is a sophisticated defense, and to put that sort of defense in front of the jury, you would think requires him to take the stand in his own defense. I don't know how else you get that defense out there in front of the jury. And that certainly even makes things more complicated, that if you're going to testify, you would want, counsel representing you to be able to guide you through a direct and a cross. And if he is claiming, insanity, he's going to expose himself to an examination by a state's expert, testimony in that regard. And it's always difficult for pro se people to cross-examine experts. That's something that attorneys are used to doing. And so it is a complicating factor and certainly weighs in favor of having an attorney present to represent him.
Julie, one last question on this topic. The jury is going to be sequestered in the case. Is this a good idea, considering the idea that they're trying to limit the amount of information that the jurors receive with regard to the killing and conviction for the killing of his ex-girlfriend?
Yeah, I mean, look, we used to sequester all the time in New York, and then we stopped because of budgetary concerns. But, we found ourselves in a position when we sequestered of having less issues with jurors reading something in the newspaper, watching something on TV, talking about it with their family, hearing about it when they walk out the door and someone's yelling something out. So I think it kind of sets a bit more of a controlled environment to prevent that information from seeping into the minds of those jurors who are making such an important decision.
Yeah, for sure. Well, Alec Baldwin, obviously in the news, and not in a way that he would like with regard to the shooting, death, and wounding of individuals on the set of Rust during a rehearsal. We're going to be talking about that and breaking it down because there's some new developments on the other end of the break, so please stay with us. Welcome back. I'm Bob Bianchi. So last week, a tragic incident on the set of Rust. I'm going to try to break down these facts as best we know them right now. It was reported that a film crew member died and the director were injured after Alec Baldwin discharged a prop firearm on the new set of Rust. A 42-year-old Helena Hutchins, who served as the film's director of photography, was transported via helicopter and pronounced dead. The film's 48-year-old director, Joel Souza, was also transported by a nearby hospital, and he has survived the incident. Rust is a Western film set in the 1880s. The sheriff's officer said the investigation remains ongoing. Over the weekend, numerous pieces of information were revealed with respect to this through affidavits that were submitted by the sheriff's department. According to those court documents, Baldwin was preparing for a film scene and was actually rehearsing the film scene. Crew members already shouted "cold gun," quote unquote, on the set, which indicates that the weapon did not have a live round. Baldwin removed the gun the first time without incident, but the second time he did so, ammunition flew out towards Souza and Hutchins. The LA Times reports on the morning of the incident, a camera crew had walked out of the filming and were replaced by non-union crew members. Additionally, there were 2 instances of prior mishaps with misfiring of the gun. in question that Hutchins had been advocating for safer conditions for her team prior to her death. It should be noted that this is not the first time people have been killed in what is supposed to be a harmless prop gun. The son of famed actor Bruce Lee, Brandon Lee, was killed in 1993 on the set of The Crow, where he was struck by a bullet from a gun that was supposed to have just blanks. The film's armorer, 24-year-old Hannah Gutierrez, had only recently wrapped her first project as an armorer. The affidavit in the search warrant says, and indicates that she was a person who set the gun prop up and put it on a table, and that it was the assistant director that gave the gun to Baldwin. Even blanks can be deadly if fired at very close range. And actor John Eric Hexum died in 1984 when he was playing around with a prop gun he put to his head and pulled the trigger. Blanks police chief of the Miami Beach, Aurora, Colorado department, Daniel Oates, said in an interview with CNN's New Day that all contain charge of powder that creates the noise and the explosive, the visual blast, and usually some kind of wire or something that explodes out of the weapon when it is fired. He went to say their weapons can be very, very dangerous. Okay, guys, so let me go to you first on this, Darren. Obviously, a very tragic incident. A lot of people are talking. Twitter was afire with charge Alec Baldwin with manslaughter, involuntary manslaughter, which would be the charge that would apply in this particular case. In New Mexico, says that if a person is doing a lawful act but does not act with due caution and circumspection, that individual can be charged with that fourth-degree felony, which carries up to 18 months in prison. Do you expect Alec Baldwin will be charged with any offense, or was this going to be classified by prosecutors as a tragic accident?
I've heard nothing so far. I mean, absolutely nothing that leads me to think that Alec Baldwin can or should be charged with a crime. I'm only basing what I'm saying on what's been made public so far. Obviously, I'm not privy to all the investigative details, but unless he had some forewarning that this gun either had live ammunition or that he was sort of recklessly handling this firearm and putting it in close proximity to people and pulling the trigger to play some sort of joke, I can't see how he should be charged with any crime. The more important question to me is what exactly was in that gun? Was it a piece of live ammunition? Was it a prop? You know, the ammunition, was it a blank? And how did this all happen? How, if it was live ammunition, how could there possibly have been live ammunition in this closed movie set? To me, that's the focus of what the investigation ought to be right now.
Yeah, Julie, I agree. I mean, the actor, Alec Baldwin, although he's a little wrinkled because he's also a producer, they have an armorer there. They have an assistant director, but it has been reported in other in outlets that the assistant director had previously had problems on other films with regard to safety, specifically pertaining to guns and explosives. And this armorer is quoted in a podcast in her own words saying how she was inexperienced and she was really nervous on her first set. This either maybe her second or third job. They are the ones ultimately responsible for putting the gun, the armorer, on the table, and then the assistant director handing it to Baldwin saying cold gun. Do they face any kind of liability not having used due caution and circumspection in your mind?
I think there's no question there's civil liability that can go around to everyone, and that includes Alec Baldwin, because my understanding is he's one of the producers on the movie. So I think the civil liability, there's no question about. The criminal liability gets a little more complicated, and I agree that we just don't know everything yet. We still don't know for sure. We believe that the gun contained live ammunition, which still blows my mind, but we don't know definitively. And so if it did, is it possible that the woman who was tasked to do this could face criminal responsibility? It's possible. I hate to say it's too early to tell. There was a comment made by someone who's familiar with these type of sets saying that Alec Baldwin was at fault because you're never supposed to point the gun at anyone, and he did. I'm not sure that that brings us to the level of a crime. But, you know, again, everyone has these different theories as to why potentially someone should be charged.
Yeah, Dan, and Darren, talk to us also about the idea that, you know, prosecutors don't dance on the head of a pin and just look for every little minor technicality in charge and let's see what the jury will do with it. I mean, at least they shouldn't be doing that. So do you think from a prosecutorial point of view that even if they see possible culpability here that they will not prosecute because they're not sure they can prove the case beyond a reasonable doubt? Well,
Yeah, I do think that's the case, and I think that should be the case. There are many cases where prosecutors may have a gut feeling or a suspicion that a crime may have occurred. But before you file a charge like that against a person with absolutely no criminal record whatsoever, you ought to know in your gut that you've got enough to sustain a conviction.
You got it. Okay, listen, guys, thank you for that great advice. We're going to take a quick break, but on the other end, we're coming back with Kyle Rittenhouse with the Kenosha murder. We'll be right back. Stay with us.
So, can you guys delete my social media accounts? Like, after you guys get your warrant to go through all my shit, can you make sure everything, like, my social media is deleted?
I mean, we can't discuss the case with you, but we'll look into some stuff, okay? But there's a lot of pieces here, okay? Reach out to us, okay? That's your prerogative. Reach out to us.
Welcome back to Law and Crimes for the Record. My name is Bob Bianchi. What you just witnessed there was a police interview of Kyle Rittenhouse, where the law enforcement are asking him to delete his social media. That's interesting. We're now turning to this case because it is going to be hot in the news, and you know we're going to be covering gavel to gavel here at the Law and Crime Network. But to refresh your recollection of this case, last August, following the police shooting of an unarmed black man, Jacob Black, protests rang out. During these protests, Rittenhouse, then 17 years old, traveled from his home in Illinois to Kenosha, Wisconsin, in response to a call from a Kenosha militia to help protect businesses from looters. According to authorities, shortly before midnight, Rittenhouse shot Joseph Rosenbaum in the parking lot of a used car dealership, killing him. And moments later, Rittenhouse shot Anthony Huber in the street, ultimately killing him as well. Just seconds after the shooting of Huber, Rittenhouse shot Gage Crosscurrents, I believe his name is, in his arm, but he survived his injuries. Cell phone footage actually captured the deadly incident. Now, defense counsel contends that Rittenhouse acted in self-defense. Rittenhouse faces multiple charges, including attempted homicide, and weapons offenses. His trial is set to start in November 1st. However, Rittenhouse will be back in court this afternoon for a hearing to decide the admissibility on use of force information. Earlier today, folks, there was a motion that was made with regard to the defense asked to have weapons charges dismissed against Mr. Rittenhouse prior to the trial. Let's listen to a little bit of that argument.
So from a plain reading of it, it doesn't, he's not in violation of that statute. If he was 16 or under, he could be. But because he's 17, he cannot be. That's our argument.
Thank you. Mr. Finger?
I think what the defense is missing here is that Chapter 29 of our Wisconsin state statutes is entitled Wild Animals and Plants, and every subchapter deals with hunting, trapping, fishing, commercial activities, fees, education, game wardens, etc. That chapter sets forth many of the rules and regulations that apply to hunting and fishing in the state of Wisconsin, which is something that is a proud tradition of many Wisconsin residents and is a very substantial industry in our state. The Wisconsin legislature, when they drafted 948.60, established a blanket prohibition that if you're under the age of 18, you can't be running around with a gun. That's the general rule. And what we have in this case is clearly a 17-year-old running around with a dangerous weapon. This case is a perfect example of why we don't want that happening, because 2 people died. Now, in recognition of our strong industry of hunting and fishing and trapping, etc., there were some exceptions carved out. And those exceptions are set forth under sub 3A, B, and C. I think those should be construed narrowly. I think the court is right that those exceptions are not intended to swallow the rule. And the defense interpretation of sub 3C would rewrite the law to say that if you're under the age of 17, you can't possess a dangerous weapon. But that's not what it says. It says 18. The defense interpretation would allow any 17-year-old to run anywhere in our our community, our state, with a dangerous weapon. That's clearly not what the statute allows. Counsel says the defendant can't comply with 29.304. Well, none of us in the room can. It doesn't apply to us. So he's not violating it. He is in compliance with it. It doesn't apply to him. However, 29.593 does. 29.593 sets forth requirements for a certificate to be allowed to hunt. Now, at trial, the state will put forth evidence that the defendant was 17 on August 25th, 2020, and had a dangerous weapon. If the defense, in their case, wants to establish that one of these exceptions applies as an affirmative defense to that charge, they can submit evidence that the defendant had a certificate to hunt and that he was engaged in legal hunting activities on the streets of Kenosha that night. I don't think they're going to be able to do that. But that's the way this would play out. And I could see a circumstance in which maybe in a more rural community, that might be a situation where a 17-year-old is running around hunting and they're charged, but then they establish compliance with these other statutes. And that may be a debate in that case. It's not going to be one in this case. The defendant wasn't hunting deer, he wasn't hunting turkey, he wasn't hunting wild game. He didn't have any certificate or training to do so. He was not in compliance.
This would not be, if the purpose of the legislation was to neuter the statute itself, it wouldn't be the first time the legislature did that either. They sometimes do pass exceptions that follow the rule for whatever reason, either by design or by oversight, and if legislation gets passed without knowledge of what's in there, that it would be easy to do exactly that. I'm going to deny the motion for now, but I'm going to. That's no guarantee I won't re-examine this. I just don't. I don't feel comfortable. It's a penal statute, and to hold people accountable for laws that, well, the basic rule, and there's plenty of interpretation on it, but the basic concept of the rule is that it has to be clear to ordinary people. And if you've got, judges spending hours here and hours or more at an appellate level trying to figure out exactly what the statute says, I mean, how does that serve the people? So I'm going to deny the motion subject to reconsideration. Without motion, I want to give more study to this. And believe me, it's not because I haven't looked at it extensively.
All right, well, joining us again, Darren Gelber, trial attorney, former prosecutor, Julie Rendelman, a trial attorney, former prosecutor, and law and crime legal analyst. Guys, let me start with you, Darren. Can you tell me what it means when the judge is saying, I'm going to leave the door open for the defense, when denying the weapons charge argument? What does that mean exactly?
I think he's going to wait and listen to the trial. And if the defense is able to come up with some sort of evidence that the purpose of Mr. Rittenhouse carrying that weapon that day was in furtherance of some lawful hunting activity, that perhaps the section that's being argued about in that motion hearing may come into play, and he'd be willing to think about the issue again at that point. But based upon the record that's before him presently, which doesn't seem to have anything to do with hunting, he's having a tough time applying that exception to the weapons statutes to excuse the fact that Mr. Rittenhouse possessed that weapon on that evening. So he's I think, cautiously leaving the door open. I wouldn't expect much more to come of that, but he's signaling to the lawyers that he has an open mind, and if some evidence comes in that seems to call into question whether this was a hunting exercise that went terribly wrong, he'll think about it again at that point.
Yeah, Julie, given all the facts that we know and the pictures that we have, do you think this weapons charge should come in?
Yeah, I mean, look, I think Darren answered absolutely perfectly. Yeah, the judge is leaving the door open. I think it's open maybe just a crack, and I don't think that in the end it's going to get anywhere. And by the way, the sarcasm that came out during this hearing in the idea that he was walking in the streets hunting, when we know, how many people were shot from that weapon. So. Look, I don't think it's going to change in terms of, in the end, unless some miracle happens and we find out that there were somehow deer and squirrel that were running rampant on the streets on that day.
Yeah, Darren, in the grand scheme of things, how much does this affect the defense's case if this weapons charge stays in?
I don't think much. I mean, there's no question, apparently, that he had the weapon. He was carrying. I mean, there's a zillion pictures and cell phone videos of him with the weapon. The question is, what did he do with it? I mean, did he have a cause, whether it be self-defense or defense of others, to fire that weapon and to use deadly force? That's the main issue here. These manslaughter charges and things like that are much more significant to the defense than a weapons possession charge at this point.
Yeah, for sure. Okay, excellent commentary as always. Well, we have Brian Laundrie and Gabby Petito developments in that situation that have occurred during the past week, and we're going to get to that when we take a break, and we'll come back on the other side of the discussion, so please stay with us.
My response has been the same. The area that they were searching was the beginning of the trailhead or near the beginning of the trail in the park. And I don't know if that is where Brian went in and stopped, or if Brian was in the park for a long time and circled back. All I do know is that you start at the beginning, and that's where they started. So fortunately, we did find what they found. Unfortunately, we've been notified, as you know, that Brian is now deceased.
That's Laundrie family attorney Stephen Bertolino giving an interview with our very own NJlawyer from the Law and Crime Network. As you know, last week, partial human remains, including a dry sack with notes that purportedly are from Brian Laundrie, was recovered, and skeletal remains were also recovered. Those remains have been positively identified as Brian Laundrie's remains. However, cause and manner of death has not been able to become forthcoming at this point in time, and the case has been sent to anthropologists for them to be able to take a look at it to see if they can get more details on the death of Brian Laundrie and how it actually occurred. He was last seen at his family's home, and where he had left on September 13th. Our very own Joseph Scott Morgan from the Law and Crime Network, who often gives us commentary as a forensic death investigator, and gave us some ideas as to why it would be that the body would decompose in the manner in which it did. Let's take a listen.
The thing about, being down there in the swamps like that is that it's so harsh. The soil and the water, everything is so very acidic down there that remains break down very, very quickly. It's like a huge, just imagine a big, how, I don't know if your parents had one of these when you're growing up, a gardening what's it called? Composting pit, where you rotate things. Imagine that on steroids in the swamp, and things just break down really, really quickly. And then you're absolutely right about the animal predation. The worst animals you have to worry about in the swamp are raccoons and possums. People don't think about that, but those little animals like that, they drag things away, and they just kind of nip at the sides. And squirrels will actually get involved too. I know people find that hard to believe. They love like the little bones and fingers and whatnot. So yeah, it's amazing. And I know, sorry, all these animals, people think they're all cute little vegetarians. They're omnivores, many of them. So it's a odd thing. But yeah, it'll be interesting. The trick is finding that skull. That's going to be the biggest problem. And the thing with skulls is that dogs love them. And if a dog came along, that skull could be anywhere. They treat them they like to feast on them, but they also like to play with them. They treat them like a ball. It's the damnedest thing you've ever seen. It really is. It's amazing. So I don't know if there's any soft tissue left. And I don't know that this guy is a handgun owner, you know, so for me, he could have OD'd or he could have hung himself, or I guess he could have cut his throat or something like that. But, you know, very few people actually do that. Very few people actually cut their wrist or cut their throat. Hanging is like the second most frequent cause of death that we come across in suicides. And then drugs are lagging behind, guns being number one. But it'll be interesting to see if they find a rope hanging from a tree out there and he fell out of it.
Darren, with regard to them only finding bones at this point in time, what do you think the likelihood is that we're going to get a cause and manner of death in this case?
It's so hard to say, Bob, but scientists like Joe Scott and forensic anthropologists can do amazing things, and you scratch your head and say, wow, how do they know this? But it wouldn't shock me if they can sort of narrow the scope of causes of death down. I don't know whether DNA testing of the bones can produce any evidence of whether drugs were involved in one way or another. Certainly if a skull is recovered and there's evidence of a gunshot wound, that would be something I think that would be within the realm of possibility that we'd be able to know. So I'm hopeful that in order to bring closure not only to the Laundrie family, but the Petito family, I'm hopeful that they're able to find something to sort of guide us in the direction, at least, if not an exact cause of how this all happened.
Yeah, and Julie, Brian Laundrie is now dead. Gabby Petito is dead. Is this case going to end now, or are they going to try to do something to tie this person of interest, Brian Laundrie, into the actual death of Gabby Petito? And if so, what do you think their most likely steps are next? Or is it just going to be, that's it, the circumstantial case, this is what we believe, let's move on here?
It's a great question. And, you know, look, we still don't know certain pieces of evidence. I remember the medical examiner, when it came to Gabby Petito, had mentioned there was DNA on her and wasn't specific as to what that is. One would assume that they're going to determine whose DNA that was. For example, if there was DNA potentially around somewhere on the neck of Gabby Petito and it was Brian Laundrie's, that would give us go a long way in proving that he's the person that did it. Obviously, we never want a situation where everyone's assuming that Brian Laundrie is the person that committed this crime, and we find out that he wasn't. I also think that, I believe there were notes recovered or some type of notebook that was recovered near where Brian Laundrie's remains were, and I'm curious what those notes have. Do they have indications of, do they have notes written by him about killing her, about suicide, anything like that, things like that that can help them kind of understand whether or not they are definite that this is the guy who killed her.
Yeah, Julie, as former homicide prosecutors, I think we both agreed by the fact that you may think it's this person, but you should dot I's and cross T's and eliminate all other third parties if you're going on a circumstantial case. So I hope they continue to do that for the Petito family so that they can try to get as much data and information as possible. Well, you guys know that in Moab, Utah, there was a domestic dispute that occurred that was captured on police body cam video. Let's take a little look at that.
Hey, so a tiny little girl, 22 years old, slapped her boyfriend, her fiance, several times. He's got a little bit of a little tiny abrasion on his chin, on his jaw. They got into a van and drove off. He got called in by two different, well, there's one caller and then a witness. Got them stopped. The story from the witnesses matches the story from the female, matches the story to the male. She was pissed off. She's having a rough day. He tries to separate from her. She's not staying away from him. She has severe anxiety problems. He locks her out of the van, says, you need to go for a walk and cool off. She's forcing her way into the van. She's clawing her way past him into the van to be with him. He's shoving her to get her out of the van, but he's not assaulting her or he's not assailing her. He's trying to keep her out. She's punching, slapping, everything. She's got to be 105 pounds soaking wet, 22, full of anxiety, having a really tough time. Not making excuses, but I mean, it is written into code. We do have a domestic assault here. He's not wanting to pursue it. He's very adamant. He does not want to pursue it. We're explaining we don't have any discretion on these things. We're giving him a no contact. We're letting Seek Haven see if they can get him a hotel so she can have the van so that we don't have to put her in jail. She's really struggling with the idea of being alone and not with him and not having the van. They want to be together. I told her, look, there's not anything I can do. This is all written into freaking statute. I just said the last thing I can do is call a supervisor and see if where this is such a minor. It was like a slap fight, and the injury is from a fingernail. I just don't know if it's worth the whole domestic thing or not, or if it's going to get us in trouble if we don't do it this way. Well, they don't want to, but I told them that unless I get some kind of permission some other way, I'm pretty sure this is just statute and that we have to separate you. Bodily injury means physical pain, illness, or any impairment of physical condition. So let's see. He's not ill. He doesn't have an impairment of physical condition. And if he's not in pain, like how far do you want to go with this? Like, you know why the domestic assault code is there. It's there to protect people, especially the reason why they don't give us discretion on these things is because too many times women who are at risk want to go back to their abuser. They just wanted him to stop, and they don't want to have to be separated. They don't want him charged. They don't want him to go to jail, and then they end up getting worse and worse treatment, and then they end up getting killed. Mm-hmm. In no way, shape, or form that I can perceive does what happened here, a little slap fight between fiancés who love each other and want to be together, can I perceive that this is going to digress into the situation where he's going to be a battered man? Right. But then again, I don't have a crystal ball.
Now, Julie, well, I mean, this is a supervisor talking to a junior officer. It seemed like the junior officer understood the statute, understood there's a zero tolerance policy, and arrest is mandated under the domestic abuse statute. And you know what's funny? The supervisor actually said, you can't make it up. He said the DV law is there to protect people, women who are at risk. Well, first of all, it's men and women who are at risk. But okay, I get it. Women who are at risk and then end up getting killed. We used to always say, right, Julie, today's domestic violence is tomorrow's homicide case. And then he then describes it as just a little slap fight. So, I mean, that's the reason they don't give discretion. That's the reason they separate the parties. That's the reason the court sort it out. You know why? Because that little slap fight very, very, very well may have led, allegedly, to the person of interest, Brian Laundrie, actually killing Gabby Petito. What do you think about this dialogue that goes on? And do you suspect these cops are going to, at least that supervisor is going to be in a lot of trouble?
It can't be worse than what we heard. And I want to ask you something, Bob. Honestly, do you think that if the table had been reversed and she had the scratches on her face that he did, because by the way, he had quite a few scratches. They were all over the side of his face. Whether you believe that he was hitting her, she was hitting him, there's no question, at least the police believed that in that situation, at least they said they did, that she was the aggressor. Do you think they ever would have released if the shoe was on the other foot and she was the one that was injured? Yeah. Absolutely not. And it's kind of ironic that this is the way they viewed it, and then look what happens afterwards. And so it does also show some lack of understanding of DV in terms of that it only can happen to women. Only women are in danger. I mean, obviously people view this case differently because they believe that she was the victim of him. But it just does give some general lack of understanding of every single thing he was supposed to be doing. He did the complete opposite.
Yeah, and Darren, not for good measure, threw a little bit in there, kind of like, we want to go through all this paperwork and all this rigmarole over a little slap fight, as he was referring to it. What are your thoughts when you listen to that? Because as you know, and I know you're a Jersey guy, I mean, any visible signs of injury, you're going in, period, end of story.
When the first videos were coming out, that was my immediate visceral reaction. That police in most police departments confronted with a situation like this in a mandatory arrest state like Utah, like New Jersey, like many other states, would have quickly come to the conclusion somebody's going as police officers. Somebody's going. It may have been Gabby Petito. It may have been Brian Laundrie. And quite frankly, it could have been both of them. That's why these domestic violence laws are so strict, because You want to take that decision-making process out of the loop, separate the parties, and let a judge address the situation in a couple days. If they want to dismiss the case in a couple days, after they've had some chance to think about it and talk to very often a court-appointed counselor, so be it. But I think in most states today, that certainly would have resulted in an arrest. And jury's point is well taken, that if the situation were flipped around and she had the tiny mark on her face, I don't think they would have thought for a half a second about whether Brian Laundrie would have been arrested.
Julie, one last aspect of this that just is like nails on a chalkboard to me is when I was, there were 21 county prosecutors, and we would go down each month and have a meeting with the Attorney General. And every time something like this happened, some group or some person or some politician would say, new law, we'll call it the Gabby Petito law, whatever. I mean, no disrespect to Gabby Petito in the least. And we would just be like, you just piling, we already have the law. The law isn't the problem. It was the execution of the law that was not followed that is the issue. So can you talk about, do we need more laws for real, or do we need officers to follow the law?
Well, you know, it's hard. I'll be honest, Bob, you know, I'm also a defense attorney now, and you are also. And so, you know, my views have changed a bit, because I have seen, and let's remove Gabby Petito and what happened from kind of what we're discussing. I've seen plenty of times where individuals have made allegations against their significant other that they admit are absolutely false, and still the police say, we don't have a choice, we must put this person through the system. So I have mixed views. This one doesn't create those mixed views, because you actually see the injuries, and actually both of them admit that a physical altercation occurred. So it's not like there's any confusion. They both admit it, and there's evidence separate and apart from what they say to show that it happened. So yeah, the law was there, it just wasn't applied correctly. That doesn't mean a new law needs to be brought into place. It means that an officer needs to learn how to follow that law.
Yeah, and listen, you know I am a big police supporter and have been for many years, even as the prosecutor. I ran all the departments in my jurisdiction, but the officer specifically says we have a domestic abuse situation here, and there should be an arrest. He's essentially admitting that, but we're not going to do it. And that is exactly to his prediction how women at risk wind up getting killed. We're going to come back with Markeith Loyd on the other end of the break. Please stay with us. We'll be right back.
These guys and girls have been working nonstop for 9 days. I'm extremely proud of them. And I mean, they've basically been living in their vehicle, using the bathroom in their vehicle to try and do everything they could to bring justice for the Dixon family and for the Clayton family. So we're very excited. A cop killer, someone who's also wanted for murder, Shade Dixon, is off the streets. The community is safer. And we can get back to the business of continuing to keep this community safe. But again, very, very proud of all the agencies that were involved. And again, the Orlando Police Department, Orange County Sheriff's Office, Metropolitan Bureau of Investigation, Florida Department of Law Enforcement, U.S. Marshals, FBI, Homeland Security, and many others that I'm probably forgetting, all played a part in this, and some great police work that got this cop killer off the streets.
Orlando Police Chief John Mina announcing the arrest of Markeith Loyd. Let's go just do a little bit of a rundown with regard to Mr. Loyd. He was accused of and convicted of killing his ex-pregnant girlfriend. That case went to trial. It was a death penalty case. He was given life, so he was spared the death penalty with respect to that case. But he went on the run. And while he was on the run for about 27 days, somebody calls up in a Walmart and says that they think that they have identified him. And a Lieutenant Deborah Clayton responds to the scene. An altercation occurs as she's calling for backup, and he shoots and kills Officer Clayton. He is on trial for that. That is a death penalty case as well. We were looking for 60 qualified jurors. We have them now. 16 will sit and listen to the trial. 12 will actually deliberate, and there are 4 alternates in the case. A juror advanced on today's round of jury selection who works in the security clearance for the government as a former officer. Let's take a little listen to that.
What's their role in law enforcement and the nature of your relationship?
Okay.
The person is a reserve, and he was my mentor advisor through college. And another person I stayed friends with after college. Different person stayed friends with after college. Do you need their employment or what? Sorry, what information do you need, sir?
What agency do they work for?
Orange County Sheriff's Office.
Okay, go ahead. Anybody else?
There is another friend that I went to the academy with. Kind of brief contact there with the Alachua County Sheriff's Office. And you're looking for law enforcement?
Yes, ma'am.
Okay. There's nobody that really sticks out to me at this point that I'm friends, that I consider a closer friend I maintain contact with. That is local law enforcement that I can think of right now.
Yes, ma'am. Anything about your relationship with those individuals or your current role or your prior role in Gainesville that you think would prevent you from being fair and impartial in this case?
Not at all. I actually think my current position enables me to be completely impartial, because with investigations, I see all the time that on paperwork and what you do after the investigation and the evidence that you get can be 180 degrees from what was on paper.
My last question, ma'am, is there anything in your background or life experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury that we can for this case? You've already given us a couple of examples, the insight into what you do. Anything like that, other than what we've discussed, that you think we should know?
No, it really was just what I had mentioned earlier. Is I understand I have a obvious background in criminal justice, law enforcement, but with my current job, it is weighing the facts, it's weighing the evidence, it's going over that in minutia, in detail, to come out with the best information to be able to make a determination.
And I should have asked you this. Your juror information says you have never been a juror before.
Correct.
Have you ever been called up like this?
I have.
On multiple occasions?
Yes.
That's why I wanted to ask this question. On a scale of 1 to 10, 1 being you can't wait to get out of here and go back to your job and your life, and 10 being you're uber excited about the prospect of being a juror, where would you put yourself?
I would say in the middle. I think professionally, this is what I've learned about and gotten schooling on and whatnot. However, I am quite active, and I, do have my own personal life. But I also think being a federal employee, I am able to take off of work and be here for the required amount of time, where I understand that is hard or nearly impossible for most people. I think I am interested, and I think I would be impartial and interested. I think that's I would be interested, whereas I wouldn't just be here out of complete obligation and required to be here and hate, like you said, hating every minute of it. I think, I guess just kind of in the middle.
Yes, ma'am. Thank you. Thank you, Honor.
And so I want to talk a little bit more about the victim in this case being a law enforcement officer, right?
Yes, ma'am.
And certainly it wouldn't be fair, I think you would agree, to the state if the jury was composed of Mr. Loyd's family, right?
Right, correct. Ma'am.
And my understanding is law enforcement sees itself as a type of family. Would that be fair?
Yes, to a certain extent.
And so, I don't think anyone doubts your ability to follow the law, right? And all of those laws will apply to you if you are selected as a juror in this case. Right now, the oath that you took was to tell the truth. And so I am genuinely asking about your feelings, right? I want you to envision yourself being in the deliberation room trying to decide if we've met our burden of proving Mr. Loyd not guilty by reason of insanity? And would you struggle to acquit him? Not guilty by reason of insanity is still not guilty of the crime of murder of a law enforcement officer, given your background?
Not if the evidence is there.
Okay. Same type of question about the penalty. So now you've convicted him. You've rejected that defense. He's been proven guilty beyond a reasonable doubt of the intentional, premeditated killing of a law enforcement officer. Thought about it, he meant to do it, and he did it. No legal excuse, justification, or defense. You're being asked to decide what the appropriate penalty is, life or death. Do you think you would be feeling pressure to sentence him to die because of your background?
Not at all.
Okay. Tell me what you're thinking.
Just that. I don't see why there would be any pressure to or expectation of me or anybody to sentence him to death.
Okay. And maybe I'll just tell you what my fear is, right?
Sure.
So some folks that have background in law enforcement, related to law enforcement officers, feel pressure, like I have to go back to my loved one, my family and friends, who at some point are probably going to realize where you are, and they may question why you did something. And some people say, yeah, that wouldn't bother me. And some people say, yeah, I think that might creep into my mind, envisioning going to talk to my friends that you talked about in law enforcement and having to explain myself. Does that make sense?
Yes, ma'am.
Does any of that apply to you at all?
No.
Darren, what do you think about the questions of both the prosecutor and the defense lawyer vis-a-vis this witness who is working for a law enforcement agency?
It's really, really interesting. And those of us who's practiced in New York are used to this sort of attorney directed voir dire. We don't have this in New Jersey. The judges do all the questioning in New Jersey. But it's so important to get a feel from the jurors about their thought process. And you really see this coming through here. This juror is giving no answers that are going to enable a successful application to excuse this juror for cause. Okay, this juror is answering every question that I can be fair, and yes, you're giving me this scenario, and I can judge this based on the evidence I hear, not as part of my role in law enforcement. And so if somebody doesn't want this juror on the jury, they're going to have to use a strike. They're going to have to use a peremptory challenge. But you don't get this sort of insight when the judge runs the jury selection. You only get it when the attorneys do it. And it's a great example of how attorney questioning can really help the attorneys decide who to excuse from the jury and who should stay.
Well, Darren, I got to go back to you because this is like a pet peeve of mine. New Jersey is about to embark upon this process of eliminating or greatly reducing peremptory challenges. They first started that it was implicit bias, then it kind of moved to like, well, it's just more effective, leaving it to a judge essentially now to pick jurors because if they don't get removed for cause, you're stuck. And so talk to me a little bit, and other states have already done this. This seems to be the new fad going in here. How dangerous is it to be in a state like New Jersey where, one, you don't get to question the jurors like these in this case, and two, your peremptory challenges are either significantly reduced or completely eliminated?
It's a disservice to litigants. It's a disservice to attorneys. Nobody wants bias in the justice system, implicit, explicit, or any type of bias. But to sacrifice a litigant's right to help pick their own jury because you think it'll help reduce implicit bias when there's no real hard evidence to even come to that conclusion, to me is absurd. And this questioning that we're able to listen to now really gives you the type of information to enable you to make a sound judgment. You're not going to get that sort of information when a judge says, can you be fair and impartial, yes or no? And the juror says yes. And then the next question is, what do you do for a living? Well, you know, the judges in New Jersey still ask questions like, what type of bumper stickers do you have in your car? It's absurd. So peremptory challenge, jury selection is probably the most important part of a trial, putting aside closing argument. I put jury selection number 2 behind closing arguments as the most important part of the trial, because you need to have some assurance that the people sitting in judgment in the case, whether it's civil or criminal or prosecutor or defense lawyer, are able to stay fair and impartial. And this is a rare issue where prosecutors, defense attorneys, civil attorneys everybody's united. Don't take away our peremptory challenges, but courts across the country, and I think in the sake of expediency and wanting to move cases along, time it. They'll tell you that it takes too long to pick a jury, so we just want to cut it down. But it sacrifices justice in the process.
Yeah, it's really a shame that we would get to a point where something so important, where every lawyer agrees, reposes that whole thing to a singular judge who may or may not even have experience in trying cases in that particular area, and you know your case, the judge doesn't. But we're headed down a very dangerous path. I have to agree. Thank you for that answer. We're going to take a break. When we come back, we're going to be back jumping into some jury selection, so stay with us. Welcome back. Okay, Markeith Loyd, jury selection beginning. This is important. The 60 jurors that have been qualified are now being questioned by the attorneys, and they have their suitcases with them, all 60 jurors, because if they get selected to sit on that jury, they're immediately being sequestered. Right now, Allison Miller, a defense attorney, is questioning one of those jurors. Let's go live.
Anyone think, you know, if I don't hear from him, it's because he's guilty? Show of hands or paddles? No right or wrong answers? You know, if you don't volunteer, this is where Mr. Williams and I do agree, we call on folks. Juror number 51.
Yes, ma'am.
Tell me what your thoughts are. Would you agree with this statement? If a defendant doesn't testify, chooses not to testify, it's because he's guilty?
No, I do not concur.
Why not?
It may be in his best interest. Maybe he wouldn't be persuasive. Maybe his lawyer says the case is going well as is. You don't need to get up there in front. We've done what we need to do. So by no means.
Okay. Would you agree with this statement? The state of Florida has to prove him guilty beyond a reasonable doubt of the crimes they've alleged.
That is my understanding what their aim is.
Yep. Or he's not guilty, right, if they fail to prove it.
Correct.
Okay. If they don't prove him guilty, whether or not you hear anything from this side of the courtroom, does that change whether or not they've met their burden? Does that make sense?
I'm your question, but I would probably. She's been what the law is in different situations.
All right, hold on then. I'm going to read you the jury instruction on this.
I was say it. She will continue to do that.
In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. You may proceed, Ms. Miller.
Thank you. And so back to you, Juror 51, in seat 51. Your juror number is, in fact, 505. It's a little bit confusing. Again, some people say to me, no problem with that. Some people say, I just know for me that I'm going to be thinking about whether or not he took the witness stand when I'm deciding if the state has met its burden in proving him guilty. Okay. And again, I want us to imagine that we're having these conversations like 3 weeks ago, before you knew anything about Markeith Loyd or jury summons, if we were just having coffee and we were having these conversations, right? Because again, I don't think anybody is setting out to try to not follow the judge's instructions by any stretch of the imagination. With me?
Yes, ma'am.
Okay. If I could ask you, let's go next door, 52. What do you think? Would you agree if a defendant doesn't testify, it's because he's guilty?
No, I don't agree.
Why not?
There's different reasons that somebody may or may not want to testify. So, and it may be, you know, he may be listening to his lawyers if they advised him not to testify.
Okay. And so I don't think I articulated this well to your neighbor. The state goes first.
All right, there we go. Continue jury selection. Julie Rendelman, what do you think about this whole process and the way it's going? It seems like extremely thorough to me, and these lawyers seem very capable. I'm sorry, Darren. Julie's off right now. How about you? What do you think?
No, it's really a testament to the attorneys. They're asking great questions, seeing whether these jurors can understand important legal concepts and whether they have any problem applying them to this case. It's a great insight into how lawyers pick jurors when they're allowed to participate in the process, like they can in Florida.
Yeah, and Darren, this whole idea about sequestering the jury is very hard on them, but smart move. Give me your thoughts on that in about 10 seconds.
Yeah, we don't want the jurors thinking about anything about this case unless they hear it from the courtroom. Certainly sequestering them helps achieve that goal very significantly, greatly reduces the chance of problems where you'll have to kick people off the jury down the road. It is a big burden for them and their families, though.
Yeah, it certainly is. And there's so many other cases that we cover here at the Law and Crime Network that I'm surprised sequestration has not been done. Nevertheless, it is being done here, but don't go anywhere. We're going to take a quick break, and we're going to have Brian Buckmire back with the Ahmaud Arbery case on the other end. Stay with us. All right, and the trial of shooting death of Ahmaud Arbery is in progress. It's been a beast, if you will. 1,000 jurors summoned. So far, they have 23 prospective jurors. 64 is the magic number that they're trying to get to, of which 12 will listen to the trial and actually render a verdict, and there'll be 4 alternates. That's 16 in total. The defendants, as I'm sure you know, are facing malice murder, felony murder, aggravated assault, false imprisonment, and criminal attempt. We have our very own Brian Buckmire, not just a TV personality, but an excellent lawyer in his own right. Brian, you're out there at the courthouse, and you were telling me that there was something going on with an interview with the father of Ahmaud Arbery that was going on with the group. Also, the initials are TJC. Tell us what that's all about and what you learned.
Yeah, Bob. So this morning, after some questionnaires we're going through, some questions asked of some potential jurors, we actually got to hear from Ahmaud Arbery's father and also 2 of the representatives from the Transformative Justice Coalition who are with him, talking about what they were seeing and hearing inside of the court. They talked about how it was interesting, how the lawyers brought up, where do you go to church? Or if you had passed away, who would you want to speak at your funeral? They also brought up, over the prosecution's objection, what do you think of when you hear of justice for Ahmaud Arbery? One thing that really sticked out for the family, though, is this is, from my understanding, the second time this has occurred, where an African-American potential juror has done some questioning, and I think the defense is getting at the notion that Mr. Arbery, the father of Ahmaud Arbery, is somewhat influencing jurors by the head nods or the pins in which he wears. That was something that both the representative from TJC, Ms. Arwine, Barbara Arwine, who's actually a co-founder of the TJC, thought that she took a little bit to heart. She was saying things along the lines of, this seems like an act of desperation to some degree, that they're trying to almost push out or push back the family of Ahmaud Arbery. But Mr. Arbery kind of took it in stride and said, you know what? It is what it is, and let's keep moving. He's going to be there. He actually walked in a few minutes earlier as court reconvened for the afternoon.
Yeah, and Brian, tell us a little bit about this encounter that occurred, that after one of the jurors was leaving, there was a head nod with Mr. Arbery, the father, and that caused some sort of sparky conversation in the courtroom. What was that about?
Yeah, so this was an African-American juror, somewhat in his 60s, had a bit of a law enforcement background in terms of at least people that he knew, but he, I think, rolled the line of, I've seen enough of the video, but also I can be impartial. I understand that that's not everything was shown in the video and that there would be greater facts that would come out, but I think that when he walked out, at least when I read the pool notes, because we all can't go in there. I'm going to be in there on Friday, so make sure to show up then. I will give you all the details as I see it myself. But right now we have amazing pool reporters who are giving the notes, and at least as I read the pool notes, I could see why a prosecutor may favor this juror, even though he said he could be impartial, and I think the defense saw or believed they saw a head nod from Ahmaud Arbery's father, which he denies, as he walked out to kind of suggest, good one, or we'll see you on the jury, or to whatever the defense may be suggesting is happening. But this was the second time, and it seems that Mr. Arbery and those who represented him kind of took it as a slight towards the family.
Yeah, Brian, there's some outstanding motions that are going on there. Can you break down a couple of them? And when can we expect that we're going to have these hearings or a decision on these motions?
So we haven't heard much about that as yet. I think what the judge is doing is somewhat sliding that back and trying to figure out or trying to get into his groove of picking a juror. As I get the reports and find out when we're expected to have those motions heard or get some kind of decision on them, I will definitely report on that. But from what I am hearing is some good news is that it seems like the jury process is starting to pick up and starting to move along. So there's an anticipation that we should be selecting jurors hopefully later this week and maybe have a jury. I mean, I would hope for the end of the week, but anticipate sometime early next week.
Brian Buckmire, Law and Crime Network, always doing a great job. Thanks, Brian. Appreciate having you on. See you later, buddy.
Thanks, Bob. Have a good one.
Okay, you got it. And that's not the only thing in this case. One of the big issues that's probably going to come up here is Greg McMichael, one of the defendants, actually tried to use his law enforcement background. Now, keep in mind, he also was removed from that position for failure to complete certain training, including firearms training, but nevertheless contacted the district attorney and left a voicemail that you can be assured is going to come into play at this trial. Let's take a listen.
Within 1 minute, defendant Greg McMichael is identifying himself as former law enforcement in an attempt to influence this investigation and an attempt to obstruct the police officer's investigation of this particular case. So, Judge, with that, this is within a minute of officers discussing with him.
And so I grabbed my .37 Magnum. It's an old Glenn County PD issue, by the way.
Within a minute, he's throwing out that his revolver is Glenn County issue. That's a 505 of that exhibit, Your Honor. He's actively inserting to investigators in this case who are on the scene of a homicide that he's former law enforcement, such that that should be a factor and weigh in their approach. And that goes directly to risk of obstructing justice. To continue on and in support of that, from 711 to 720.
Hey, give me just a minute. You know, I was chief investigator with the DA's office for 23 years, so I know what you got to do. I know everything, you know. Yeah, we're just, you know.
The defendant, Greg McMichael in particular, is very quick to insert himself and tell that he has some sort of law enforcement training above the average person. And you've heard of the post records in rebuttal of that to show that the contrary is actually true. He was not post-certified for a number of years. To continue on.
Let's go. So I haul that into my bedroom, get my .37 Magnum. It's just Glenn County PD issue, by the way, that I told you years ago.
Poses significant risk of obstructing justice by inserting things that are irrelevant to the case in the hopes that that will impact what these investigators were doing at the time.
Okay. All right.
This is the coroner asking questions of law enforcement.
Any information? I do not.
Okay.
Yeah, there was a struggle. He ended up getting shot in the chest, from what I understand, 2 times.
Does he live around here?
Not that I know of. The victim? He makes frequent trips to the neighborhood. He gets caught on video cameras like every 3rd or 4th night breaking into places, and nobody's been able to catch him. And having recognized him from the video I'd seen not too very long, or several days ago, I'm standing out my front yard. He comes running by my. I'm not talking about trying. I'm talking about hauling ass past my house. I ran inside to get my son. I said, "The guy that we saw the other, or he saw the other night." I said, "He's running down the street." So that's when we started trying to find him, trying to catch him. And I left my cell phone, so I couldn't call anybody. Travis had his, but he was busy driving.
Note how quickly the defendant is to insert himself into the investigation of this case, which goes to prong number 4, significant risk of obstructing justice and influencing the investigation.
Jackie, this is Greg. Could you call me as soon as you possibly can? My friend and I have been involved in a shooting, and I need some advice right away. So please call me as soon as you possibly can. Thanks. Bye.
All right, Darren Gelber is a defense attorney, trial attorney, former prosecutor. Julie Rendelman is also the same and a law and crime legal analyst. So, Julie, let me go to you. How damning is this video being played for the jurors with regard to this call McMichael is making to the district attorney?
So maybe I'm not going to give you the answer you want to hear. I'm not sure how damning it is. Again, I don't think it's unusual, to call the person that you worked with to ask them, advice about the case. I don't think it rises. I think the bigger issue is for the district attorney that took the call and did what she did. But in terms of the defendant himself, I'm not sure that it rises level. By the way, when they respond to the scene, there's an argument to be made that he's literally providing them with the information, which is, this is a gun that I got from working here. By the way, the fact that he lies, yeah, it doesn't help him in terms of his certification, and that can be brought out. But it seems to me that he's providing information. Now, whether you believe it or not is separate, but I'm not sure that it's as damning as perhaps other people do.
Yeah, and I'm asking about damning or not damning. The question is, Darren, what do you think? I mean, is it a good look for the defendant? Is it neutral? Or are prosecutors going to make a big deal about this?
I don't think it's particularly helpful for the defendant. I think it does show some feeling on his part that he's trying to impart to the investigating officers that they should cut him some slack or treat him with kid gloves. And I don't think that's ever helpful when that comes out to a jury. We see it time and time again when politicians get stopped for traffic violations or things like this. Once you bring up your status as related to government in some way, you immediately cause a visceral reaction in people that you're trying to get some preferential treatment. I mean, I don't think it rises to the level of obstruction. I agree with Julie. I didn't hear anything that really cries out as obstruction or hindering or something like that. But I do think it is some small evidence that he's trying to curry favor with the investigating officers, maybe because he has some consciousness of guilt that he's done something wrong or that he's going to be called to account. There's going to be a lot of questions asked, and he's trying to set the stage early to go light on him.
Okay, Julie, let's add this to the fact that District Attorney Jackie Johnson was indicted for violating her oath of a public official by preventing two officers from making an arrest in the case. One, does it get in? If it gets in, how bad is that? And maybe that adds to the voicemail message in the first place.
I don't see how it would get in. This is open criminal case against a separate person, and I don't think whether or not she did or didn't do anything has anything to do with whether or not these specific individuals are guilty of this crime. I think it would be highly prejudicial to bring out that the DA was indicted. And by the way, she wasn't indicted for the conversation. She was indicted for actions she took herself, or let's say didn't take, that are separate and apart from the defendant in this case.
Okay, very good, guys. Appreciate it. We're going to take a quick break, but we'll come back on the other end. Kyle Rittenhouse will be next. Stay with us.
And you've reviewed this for whether or not Kyle's actions were reasonable under the self-defense law of Wisconsin?
That's correct, under the Wisconsin statute.
And do you have an opinion as to that to a reasonable degree of scientific certainty?
I believe the actions comport with it, and that self-defense, as described in the standard, not speaking as a legal opinion, but I do believe that they were reasonably necessary.
All right, that's testimony from a pretrial hearing of an expert witness, John Black. The defense wants to call him as a use of force expert, and that pretrial hearing is whether or not the force was reasonable or not reasonable. The judge will be deciding on that supposedly today at 3:15. I believe that's Eastern time. Let me refresh your memory a little bit about the Kyle Rittenhouse case as we get ready for that upcoming trial. Last August, following the police shooting of an unarmed man, Jacob Black, protests rang out. During these protests, Rittenhouse, then 17 years old, traveled from his home in Illinois, Kenosha, to Kenosha, Wisconsin, I apologize, in response to a call from a Kenosha militia to help protect businesses from looters. According to authorities, shortly before midnight, Rittenhouse shot Joseph Rosenbaum in the parking lot of a used car dealership, killing him. Moments later, he shot Anthony Huber in the street, ultimately killing him as well. Just seconds after shooting Huber, Rittenhouse shot another individual in his arm, but that individual survived his injuries. Everything was caught on cell phone. Now the defense claims that Rittenhouse was acting in self-defense. Rittenhouse faces multiple charges of murder, attempted murder, and firearms offenses as well. The trial's been set for November. First, however, Rittenhouse will be in court this afternoon, again, to determine whether or not the use of force expert by the defense will be admitted. So more from the pretrial hearing from that use of force expert. We're going to give you a clip so that you can take a look at that right now.
This is, at least as depicted by video evidence, and other interviews as well, the only person that's actually going up now that has a firearm. This person has a pistol, and that makes a difference. And then the other thing that's sort of happening about that is there's really a difference in the movement pattern of this one, because at this point, after Mr. Rittenhouse had disengaged from, if I'm making sure with your count, we'll call him Skateboard Man, just to make sure we're not using numbers. If he had disengaged from Skateboard Man, we now have a third person in event 2 approaching and coming up on him. And that's, for lack of a better term, interesting. Go ahead.
And that individual has a firearm in his hand, correct?
Yes.
Describe the interaction between Mr. Rittenhouse and assailant number 3.
Yeah, there's a lot of stuff going on in here, and one in particular is we've got the approach. So the first thing is assailant number 3 closes distance. Now, we talked earlier about context. He closes distance with someone that has been wrestling over a firearm, and up to this point had discharged his weapon multiple times, that we would argue that assailant number 3 would have been aware of this. They've seen the idea. Now, at the same time, he hasn't sprayed the crowd. He hasn't done anything.
When you refer to he, I'm sorry to interrupt, but when you refer to he, who hasn't sprayed the crowd?
And absolutely correct. That's my fault. Kyle Rittenhouse has not taken his firearm and basically just pulled the trigger without any regard to anything and just sprayed the crowd, as a vernacular, to get back. But he has had very directed fire, deliberate choice in very specific context. The specific context would appear to be, I need to maintain control of my weapon. What's odd, I guess would be a better term, is that the third assailant has his hands up, we'll call it a universal symbol of either surrender or peace, or the fact that I'm not an aggressor. I mean, in fact, we still shake hands today to show we don't have a weapon in it. We still do these type of things. Even the military salute to some degree is based off of that history. And yet when I'm doing this, I still at some point, I being the third assailant, I change my movement pattern. And you can actually see it in the video where I load, which means I sort of, if anybody's ever sprinted or about to push something, like even push a door open when you came into the courtroom, you sort of brace off your back foot while you're loading up so you get better contact and better connection with the ground to apply your musculature through the door. You can actually see assailant number 3 load and go forward and re-engage. And you see that also not only by the loading of the foot, but the dropping of the torso and the shoulders. And so the thing is, this would be in direct contradiction to an expected behavior of someone doing something else other than moving in. And then ultimately with that one big, large step, when you see them stepping in, and don't forget the context, there's still people running around with wooden objects, potential things to hit people with and these type of things. And basically the third assailant ends up getting shot one time as that type of dynamic is occurring.
As he gets shot from the first position with his hands up to when he's shot in the arm, is he moving away from Kyle Rittenhouse or moving towards Kyle Rittenhouse?
I would argue that the evidence shows that he is moving towards. But again,
and that's where he struck once in the arm?
In the bicep, if I recollect correctly, yes.
And that's the last shot that Mr. Rittenhouse fires on August 25th of 2020?
Yes.
And Mr. Rittenhouse then gets up from his seated position?
Yes, at least as depicted in video.
And he begins heading down towards the police line on Sheridan Road?
Correct. He continues to head in the same direction that the beginning of the event started.
And in the videographic evidence, there's 3 more shots in quick succession?
Yes, and that, yeah, you can hear it on the soundtrack, but yes.
And does Kyle shoot at those shots, or the direction those shots are coming from?
Does Kyle can you rephrase that question, please?
Does Kyle take his firearm and fire in the direction that he perceives those shots coming from?
I don't know where Kyle perceived the shots to be coming from, but I don't see any indication that Kyle fired any shots based on that stimulus.
He does turn around shortly after the shots, correct?
Oh yeah, he turns around from the sound, but again, I don't see any indication that after he turned towards the sound, he also fired his weapon.
Okay, so that's a preliminary hearing to see whether that witness that was testifying, John Black, will be allowed to testify for the defense as a use of force expert. In that right-hand corner, you may have noticed an individual sitting there listening, and his title was just Bob. That's the state's expert witness on use of force. Darren, let me go to you on this. We anticipate a ruling by the court at 3:15 today. Do you see the judge not allowing this testimony or allowing the defense expert to testify?
I see the judge not allowing this testimony and not allowing the state's expert. Whether or not force is justified is peculiarly, that's always a tough word for me to say, peculiarly the province of the jury here. And the expert cannot usurp the function of the jury on this very, very important question. He has no better expertise once the law is explained on this area than the jurors do. We can hear the testimony, we can look at the videos about what happened, the distances, and we can see things on the video. This expert's interpretation of the video adds nothing to the decision-making process of the jurors once the law is explained to them. So I don't see the judge allowing any expert testimony on the reasonableness of the use of force in this case.
Yeah, Julie, and the audience may get confused. I mean, the first thing that I was thinking about when I was listening to this is that essentially they want this witness to testify, as Darren is suggesting, to the ultimate conclusion that is in the jury's province as to whether the force was justified or not. But typically, use of force experts occur in police practice cases where an expert could testify as to policies and procedures and training in order to offer the jury some expertise in that area. Do you share Darren's thoughts that this is not going to be admitted?
It's funny, I share his perspective that I'm not sure it should be permitted. I don't know that it's not going to be permitted. And so, by the way, I found this use of force expert quite confusing. I hope he does better if he does in fact testify, or, depending on what position you're in, just because I had trouble actually following him in regards to what he was saying. And quite frankly, I think it's true that the jury can, look, no matter what, the prosecution and the defense is going to have to break up every single step of every moment that every shot was fired, because is so much going on with so many people in terms of what the jury can view as to what was reasonable in the mind of the defendant at the time he fired each shot against each individual. So it's complicated enough, let alone bringing in some expert who's going to try to explain what jurors are already looking at.
Darren, if these experts do get in, as you know, a lot of times it could be a battle of the experts that are offering two different opinions. And that's why it is so important for the lawyers to make sure they get the top-notch person. They look at their background to make sure there's no credibility issues, prior testimony they've given to make sure they can't be cross-examined or say anything contradictory in their conclusions with respect to the case that you're actually trying. So experts can make a big difference. But in a certain sense, if the defense and the prosecution are allowed to use this expert, does it create a battle of the experts there and kind of take the jurors' attention off the common sense of the thing?
Of course, I agree with you. That's always an issue when you have experts, and when you have dueling experts especially. It does seem to boil down to a battle of the experts, and that may be another reason for the judge to rely upon if it's even a close call about whether to let them testify. So I don't know much about the background of the defense expert. I don't know anything about the background of the prosecution's expert in waiting. But certainly as politically charged a case as this, there are going to be questions about who's paying the expert's fees on behalf of Mr. Rittenhouse. Does the expert have some political agenda that he's expressed in other forums? I'm not suggesting he does or doesn't, but these are things that may come out if they do exist.
Julie, if you were the prosecutor in this case, would you prefer no experts testify? But if one does, then you get yours, obviously, to counter them. But would you rather not have any expert testimony?
I mean, that's hard to say. It depends on who the expert is. Again, if it's an expert that I think I can destroy, then darn right, I want to have that expert on the stand, because if I can destroy them, then the jury, in a sense, may ignore what they see and only focus on the fact that they don't find the defense's expert credible. So it really depends on who the expert is, what my experience is with that person, what I know about them, in terms of making that ultimate conclusion.
Let me say the question another way, Julie, just to follow up. If you had the choice as the prosecutor, you were the sole arbiter of this decision. I get an expert, which means they get an expert, or I don't get an expert and they don't get an expert. Which would you rather have in this case as a prosecutor?
See, but again, it depends on, I hate to do this, it depends on who my expert is. I mean, there are so many quote unquote experts in so many cockamamie fields, and I don't believe half of them. So, we used to have experts called on everything. And so if I thought I had an expert that I knew was rock solid, then maybe I'd want to go down that road and be nervous that a jury is just relying on that moment by moment. So sorry, I'm not giving you the answer you want.
No, that's right. That is. Julie, you keep saying giving me the answer I want.
It's my mood. It's my Monday.
The Rendelman always renders excellent answers. So no worries whatsoever. Mood. Okay, guys, we're going to take a quick break here, but we got Markeith Loyd coming up next. Killing of an Orlando police officer. Obviously, a very important case. We'll be covering it gavel to gavel here at the Law and Crime Network. So stay with us. We'll be right back.
Out of all the gifts I got, this is one of the best, or I have received, this is one of the best. Because I always hugged her in her uniform, even before she went to work, while she was on duty, because we were that close. We talked every day, every hour. So it's like, seeing this patch, feeling it again, I thought I'd never be able to feel it. It's just amazing. I'm very thankful for it, to Megan. It's amazing, I love it. I really do.
Very sad and tragic. The victim, Lieutenant Deborah Clayton's son, holding a teddy bear with his mom's uniform on it. Certainly a tear-jerking experience and a sad case. We're going to be covering it gavel to gavel here at the Law and Crime Network. Once we get this jury selection done and over, we're looking for 60 jurors, of which 16 will be selected from that qualified jury. 12 will actually be deliberating on the case at the end of the presentation of the evidence and summations, and 4 will be alternate jurors. Then you may remember this facts of this case. If you follow the Law and Crime Network, we covered gavel to gavel where Markeith Loyd was charged with killing his ex-pregnant girlfriend. going on the run for a number of weeks. A person at Walmart called into the officer, Lieutenant Deborah Clayton, that the individual Markeith Loyd was there. A confrontation ensued. She called for backup. Markeith Loyd is accused of killing her, and that is why he's on trial. In the first trial with his ex-girlfriend, he was given a life sentence. He was spared the death penalty. This is a death penalty case as well, and he is going to be raising the issues of insanity, and obviously the defense wants to make sure if he is convicted that he doesn't receive the death penalty. On Friday, there was a motion as to what can and can't be said in opening statements. A lot of motions in this case, a little different and atypical from some of the other trials we've seen. But let's take a listen to the prosecution's argument about what can be said in opening statements.
It is very unclear to me, I'll be doing the opening statement, what I can say and not say, but I will do my best to deal with that over the weekend and address it on Monday. The second thing is, I know we've been talking about what defense counsel plans to present, but I'm uncomfortable with defense counsel discussing any of what Mr. Loyd just discussed in opening statements because I don't see how it's relevant or admissible. So while it may become relevant or admissible during the trial, and I don't want to object in front of the jury during opening statements. It's not my style to do that and interrupt. So I would like to know again, and I know it's difficult for Your Honor because the sands are shifting for all of us, but I would prefer to not have to object during Mr. Lenneman's opening when he's going to testify to something that may or may not be admissible at all. Is Your Honor asking our opinion?
Not really, but I have a feeling that you desperately want to give it to me, Mr. Williams.
We would prefer the latter with the understanding. My understanding is that we're still permitted to say that Mr. Loyd had a warrant for first-degree murder.
Yes.
But the state's intention based upon the court's statements, I'm interpreting as a potential ruling, is that we would not address that murder at all other than to say Mr. Loyd had a warrant in opening statements to make the playing field as level as it can be.
Mr. Lenneman, your response to me telling you all, beyond saying he had a warrant for Ms. Dixon's, for the arrest, a warrant for his arrest for the Dixon homicide, nobody's going to talk about Dixon in openings until I hear some testimony from the stand. Because, I mean, quite frankly, Mr. Lenneman, this is an ever-changing situation, and it has become difficult for even me to follow what it is you intend to say in opening. And the state, since you go after the state, it's unfair to the state. So the more I talk, the more I'm leaning towards nobody's talking about Dixon other than to say there was a warrant for his arrest.
She gave a couple of press interviews, which my client believes were distorted, and I don't know if I'm going to move that. Yeah, so and then in response to her reaching out to the police, they told her they're not responsible. And then based on all that, my client's state of mind was that's the part of Dixon that I plan on introducing. I don't plan on getting into any other part of Dixon in the case other than that.
However, by saying that your client, your terminology was, didn't gun her down in cold blood. Is that what you just said?
No. What they
gun her down.
He goes to the door. She opens the door and she's at the door. That was the information that the press was generating.
The state can then, in their opening, rebut that. They can present what, in their opening, evidence that would be contrary to what you just said if you intend to use that in the guilt phase of this trial. Because you cannot just stand up and make statements and expect that the state doesn't get to introduce evidence to the contrary.
Well, first of all, there's no evidence that supports the contrary. We have 3 press reports.
We have a conviction for let me make myself clear to everyone here, okay? I'm going to let you present your defense. Mr. Loyd was convicted of murdering Miss Dixon, her unborn child, and the attempted murder of her brother, her mother, and I think the other brother. I can't even remember. It was 5 counts. That case was PCA'd. It's a done deal. We are not relitigating his guilt, all right? But if he's going to stand up and claim, if you're going to stand up and claim on his behalf in openings that he did not murder Ms. Dixon, the state gets to talk about it in their opening.
And then whenever they open the door, we then get.
Correct.
All right, so Darren, interesting arguments here. The defense is saying if anything comes out about the murder case with regard to Ms. Dixon, which is why the warrant was issued, which precipitated the lieutenant from encountering him, was obviously the prosecutor wants to use that as motive. The defense saying that it'd be a free-for-all, and they want to stop the prosecution from having any reference to it whatsoever, which I think we all agree is not going to happen. The judge is basically saying that, you know what, I'm limiting it to that there was a warrant for his arrest in the opening statements, and that's it until I hear the testimony on the witness stand. Now, Darren, it's not unusual for a judge to say, I'm going to wait to make a ruling until I actually see as the case unfolds and whether or not there's relevancy to it, it actually comports with the evidence rules. What are your thoughts about how the judge is approaching it so far?
No, I think the judge is spot on here. And I think if you talk to trial judges, they would tell you that they hate making these in limine rulings, as we call them. They hate deciding what's admissible and what's not admissible before the trial even starts if they can avoid it. Because they don't have, they only hear what the lawyers are telling them. They don't have the opportunity to hear it from the witnesses, and they're not exactly sure how it's going to come out. And so unless it's painfully obvious, I think judges oftentimes would prefer to defer rulings toward the middle of the trial. Now, in this case, I think the judge is very keenly aware that if the issue is raised that somehow the defendant is not guilty of the murders that he's already been found guilty of, that she's going to quickly lose control of the trial, and the trial is going to become a free-for-all, a la Durst. And I'm sure that's something she doesn't want. It's going to prolong the trial. It's going to be distracting. And really what's important here is not whether he was actually guilty or not guilty of that murder. The question is, did he know, and was there an active warrant for his arrest? Because that's the motive here. So I'm 100% behind the judge's ruling on this issue so far.
All right, Julie, hear me out, and you're free to agree or disagree. I know it's Monday. I don't care. But as a former homicide prosecutor myself, I would be screaming bloody murder that, no, Judge, I want a ruling right now on whether or not I can bring out that this was a murder, to have me open up to just that there was a warrant, loosey-goosey, can be anything. You need to make that evidential ruling right now. I'm not looking to get into any more depth of the facts, but it goes to the quality of the reason that he did this. And this is important, and I form opinions in my opening statement. We always say openings could be the most important part of the trial. That's what I would be arguing. How about you, Julie? Would you at least argue that, Julie? Would you give me that? Would you at least argue that?
100%. I'll be honest, it's great that judges don't want to make decisions until the middle of the trial, but part of their job is actually to make the decisions. And there's no question that the fact that the prior case was a murder is relevant. I'm going to take it a little step further, a la Durst. I hate to do this, but I think it's also relevant to some degree whether or not he's guilty of that. Because if you have a guy that knows he didn't do anything, then there's an argument to be made that why would he be killing the officer? He might just turn himself in. This is a guy who knows he committed a brutal murder, and so therefore he's going to do everything in his power to make sure he doesn't get caught because he potentially knows how strong the evidence is. So I think the judge can go a little bit further than just simply saying it's a murder in order to be able to allow the jury to fully understand what was in the mind of this defendant when he committed this crime, weighing the probative with the prejudice.
Yeah, Darren, this is, look, I get the idea of the judge waiting for the evidence to come out when they make evidential rulings, but this is a really key, important part of this case. This issue is not going to go away. Irrespective of after opening statements, the prosecution is going to be making arguments that this information should be admitted. The court's going to have to make a ruling. But if when I was prosecutor and I was prosecuting cases, I would really be deflated by this because I want the jurors to understand what Julie just said, the gravity of what he was facing as the motive as to why he would kill a police officer. This wasn't for spitting on the street or stealing a piece of bubble gum. This was for actually killing his ex-girlfriend or his girlfriend who was pregnant at the time, maybe not getting into that detail, but then the juror is going to have a much different perspective in that opening statement if the prosecutor's allowed to do that. No?
I hear the argument, believe me, and if I were the judge and the prosecutor said, well, I want a ruling right now, the ruling is you're not getting into it. That's it. You're going to be able to say that there was a warrant for his arrest. The warrant was for a very, very serious offense, murder, and that's it. Because we don't want the jury to get distracted and have another trial of the murder case, which has already been concluded. We want to focus on, did he kill the police officer? Did he kill the lieutenant? Was his mental state at the time, does it qualify for insanity or not? And we're not going to let this case devolve into another trial of a murder case. We're not, of the other murder case.
And I agree with that completely. I'm just speaking to the terms of having the prosecutor at least be allowed to open up to the fact that that warrant was for a murder. That's all I need at that point in time as a prosecutor. Okay, guys, great commentary as always. We got Ahmaud Arbery coming up on the other side of the break and the developments with respect to that case. So stay with us. We'll be right back.
That this case is going to play out like we have been talking about for so long now, that this is a well-intentioned young man and father who were simply trying to do the best that they could, along with the other members of their neighborhood, to control the crime, to understand it, and to get the police involved as quickly as possible. And in doing so, thought that they had an opportunity to keep an eye on the number one suspect that they believed was doing the thefts in the neighborhood and that they believed was dangerous. And in doing that, in trying to keep an eye on him, in trying to engage him in conversation, in trying to talk with him and say, can you just tell us what's going on back there? Or what's happening? Or what are you doing here? In that conversation, he responded with nothing. No explanation, no anything, until the point that he decided that his way out of this detention was to attack Travis, who then had no choice but to try to keep control of his firearm and ultimately pull the trigger.
All right, that's the attorney Jason Sheffield for Travis McMichael in the death of Ahmaud Arbery with Linda Kenny Bodden from the Law and Crime Network. Jury selection started last week. As of Friday, we have 23 prospective jurors. The magic number is 64. They're looking to get to 64 jurors, 12 of whom will actually decide the fate of the defendants in this case, and 4 that will be alternate jurors. There have been over 1,000 jurors that have been summoned for this case, and the defendants are charged with malice murder, aggravated assault, felony murder, false imprisonment, and conspiracy to commit felony. So we also have some updated information right now that a Greg McMichael, who is the attorney for Laura Haug, asked to add more voir dire questions, including opinions on how long it took the defendants to be arrested, what they knew about the citizen's arrest, would they want someone with their life experience on their own jury. The state wasn't prepared for this. The judge asked the defense to discuss something like this with the other side first. And looks like he'll take it up later. And he continued with jury selection for now. So let me go back to our guests. Julie, taking a long time to find this kind of jury. So what are your anticipations in terms of what kind of jurors do you think the prosecution and defense are looking for, given the fact that many of these jurors have already expressed concerns about sitting on a trial of this nature?
I think when you heard from Brian, one of the indications that Brian Buckmire indicated was that, things are going a little smoother. They do tend to go smoother as things go on, because I think the judge, the defense attorneys, the prosecutors tend to get to hone in on those areas that they can either more broadly get rid of individuals or kind of, focus on those things that, maybe initially they thought were an issue that aren't an issue. And so hopefully it'll go a little smoother. I mean, again, it's so difficult to get a jury on any homicide trial, let alone a trial of this magnitude where, again, the world's watching. And so there's going to be a lot of feelings regarding sitting on this type of jury and strong opinions on either side.
Yeah, Darren, to that point, there's strong opinions, and we've seen, especially with the celebrity of trials that's occurred ever since, I guess, OJ and moving forward, that there are jurors who want to be on the jury and don't necessarily answer the questions as accurately as we wish. Does that inure to the detriment of the prosecution or the defense in your mind?
It's a wild card, and I think either a prosecutor or a defense lawyer who gets a sense that somebody is looking to get on the jury or is welcoming the opportunity to be on the jury or wants too much to be on the jury, they're going to go. I don't care if you're the prosecutor or the defense lawyer. The last thing in the world anybody wants or needs is some juror who's got an ulterior motive, is thinking about writing a book after the case is over, wants to see himself or herself on TV, interviewed after the verdict. It's just too much of a risk, too much of a wild card.
Yeah, Julie, are we seeing this more and more since you've been trying cases over your career? I mean, I certainly have it. The media is such an influence over jurors. What are your thoughts?
I think it's the media. I think it's the idea, that, again, when we're not dealing with sequestered juries as well, the jurors walk into courtrooms with the media outside, with protesting outside, with strong opinions, people expressing this. So people are scared to walk back out the door unless they give them the answers that they want. And so it makes it harder and harder. And that's the job of a judge, to kind of control that and to find outlets so that these jurors are not running into this left and right.
Yeah, Darren, I mean, that is true. We've gotten to a point where people are starting to become afraid and trying to vote in that jury box because they're worried about the court of public opinion. Have you noticed that in your career? And I got about 10 seconds.
Yeah, and I think more and more you see courts allowing jurors to come in through a back entrance so they don't have to go up the front steps where all the media is. If you're the court, you want to protect these jurors as much as you can from outside influences, and that starts from the beginning.
All right, Julie, Darren, thank you so much. Great being with you guys today, but don't go anywhere even though I'm done because Michael Bryan is up next. I'll see you on Thursday from 12 to 3. Have a great week.
I sold my diamond ring with Worthy.com.
Their team of experts helped me understand its value.
Then they held an auction for their exclusive network of buyers.
So I got way more than the jeweler offered.
Sell your diamond jewelry for more with Worthy.com.
It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight.
We are going to make sure that we find justice in this case.
The 3 men charged will now stand trial.
I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
You're a passerby coming through?
Nah, not necessarily.
That's my son that shot him. I was in the back of the truck.
Watch live gavel-to-gavel coverage this week on the Law and Crime Network.